The next two modules will deal with the topic of conditions. This module will introduce that topic and focus on express conditions, conditions that the parties themselves include in a contract. The next module will examine constructive conditions, conditions that the law imposes on contracts, and then consider the topic of material breach. Thus far, we have focused on promises, duties undertaken by a party in entering into agreement. We will now consider conditions. Let's begin by contrasting the restatement's definition of a promise with the definition of a condition. We learned in Section 2 of the restatement that a promise is the undertaking of a duty by a party to do something in the future. The parties' mutual exchange of promises provides the consideration that makes the contract enforceable. In contrast, a condition is not a duty or an obligation at all. It is an event that may or may not occur in the future on which one party's performance is made contingent. If that event does occur, then that party must perform its contractual duty. However, if the event does not occur, then that party is relieved of its performance obligation. There's nothing mysterious about conditions. In all likelihood, they were a regular part of our childhoods. We all remember being told by our parents at the dinner table that unless we finished eating our vegetables, we could not have dessert. In that case, eating your vegetables is the condition, the event on which getting dessert is made contingent. Unless that event occurs, you don't get dessert. Conditions that are added to contracts by the parties themselves are known as express conditions. Adding a condition to a contract can serve different functions. Let's explore several. A condition can be used to allocate the risks that each party assumes in entering into an agreement. Consider the following. John's interested in buying a tract of land for a strip mall. Mary owns land in an ideal location. The problem is that the land is currently zoned for use as farmland. Mary's filed a petition with the zoning board to change the use classification from farmland to commercial. Because he's interested in Mary's parcel of land, John is happy to enter into a contract to buy the land, but he only wants to close on the deal if the zoning change has already been approved. This is a perfect situation for including a condition into the contract. John wants the contract to reflect that his obligation to close the deal will only arise if the zoning board has previously approved the change. In such a case, the parties could agree to put a condition in the contract along the lines of the one set forth in the slide. In this example, had John entered into the contract unconditionally, he might be stuck with property that was not usable for his intended purpose. By including the condition in the agreement, he avoided the risk of the zoning boards not approving the rezoning. Conditions can also be used to sequence the order of performance of the parties' duties under a contract. So let's consider an example. A homeowner hires a contractor to build a garage for $20,000. The homeowner doesn't want to pay the contractor up front before any work is begun. On the other hand, the contractor doesn't want to complete the entire project before getting paid anything. This is another ideal situation for using conditions in a contract to structure progress payments. Accordingly, the contract might tie the owner's obligation to make periodic progress payments to the contractors having completed specific construction milestones. In this example, the contractor's right to receive each progress payment is conditioned on the contractor's completing an event, a specific construction milestone. But this case also illustrates the fact that on occasion a condition can be implied in the agreement of the parties. Despite the lack of explicit languages, it is a reasonable interpretation of this contract that the contractor's duty to continue working on the garage after satisfactory completion of each construction milestone is conditioned on the owners making the required progress payment. Yet another use of conditions is to set forth procedural requirements that act as prerequisites for one party's performance. A common example is found in insurance policies. The insurance company's obligations to pay out under the policy is often conditioned on the insured's having first given notice to the company within 10 days of the occurrence of the loss for which it is seeking compensation. When a party's performance under a contract is conditioned on the occurrence of an event and that event does not occur, what are the consequences? The restatement sets forth two distinct consequences. Section 225 states that a party's performance obligation that is subject to a condition does not become due until the condition occurs or its non-occurrence is excused. We will consider excusing conditions shortly. So in other words, the performance obligation of the party whose performance was conditioned on the event that did not occur is suspended. Second, when the event on which a party's performance is conditioned can no longer occur, then the party is entirely discharged from that duty and can walk away from the contract. Subpart 3 of Section 225 makes a very important point. If one is dealing with a pure condition, the failure of that condition to occur is not a breach of the contract on the part of either party. In other words, no one is liable for damages if the event does not occur. On occasion, a contract will contain a condition that is also a promise. That is to say, one of the parties will assume a contractual duty to bring about the event on which the other party's performance is conditioned. Such a term in a contract is known as a promissory condition. So let's consider such a case. A developer wants to buy a tract of land on which to build apartments. The land is very hilly, and prior to purchasing the property, the developer wants the seller to grade the property to a level grade. In such case, a promissory condition can be added to the contract that both puts the obligation to level the property on the seller and, in addition, conditions the buyer's obligation to close on the agreement on the seller's having first graded the land. In this case, if the seller fails to grade the property prior to closing, not only is the buyer relieved of its obligation to close on the deal, in addition, the seller will have breached the contract and the buyer can recover any damages that result from that breach. In general, a party will agree to being subject to promissory condition only if it has control over the occurrence of the event on which the other party's performance obligation is conditioned. So to give an example, suppose company wants to hire Mary as an assistant manager, but only if Mary completes the MBA program in which she is currently enrolled. The company can legitimately require Mary's graduation to be a condition to its obligation to hire her, but Mary would be foolish to also promise to graduate. Her graduation is an event that is not entirely within her control. She could be in an accident or become gravely ill and be unable to graduate. One must be careful to distinguish between a term in agreement that is a condition on the one hand and a term in an agreement that simply sets the time for performance on the other. Consider a clause in a contract between a general contractor and a subcontractor that reads, "Payment is due to the subcontractor 10 days after the owner has paid the general contractor for the subcontractor's work." Courts generally interpret such clauses not as conditions, but rather as setting the time for performance of the general contractor's payment obligation. Were the owner to go bankrupt before the end of the 10-day period, courts do not read such a clause as conditioning payment to the subcontractor on the owner's having first paid the general contractor. In such a case, the general contractor would still owe the subcontractor for its work. One way to distinguish a condition from a mere statement of the time for performance is to look for conditional language in the contract. Language such as on condition that, subject to, unless, provided that, or if. Having said that, there is no magical language necessary to create a condition. A court will determine whether the language used indicates the party's mutual intent to condition one party's performance on the occurrence of some event. Where the parties themselves insert conditional language in an agreement, we have what is referred to as an express condition. As illustrated by the Oppenheimer case, courts strictly construe express conditions. For example, assume that an insurance contract conditions the insurer's obligation to pay for a loss on the insured's having given notice within 10 days of the occurrence of the loss. Because courts construe express conditions strictly, if the insured gives notice on the morning of the 11th day, in all likelihood he'll be out of luck, absent some very compelling excuse. It's important to think about the implications of a court's determining that a term in a contract is a promise versus the court's determining that a term is a condition. If a term is construed by a court to be a promise, and one party fails to fulfill that promise, that party will have breached the contract and be liable for damages. As a general matter, however, the other party will not be relieved of further duties under the contract. It will have to continue to perform under the agreement and collect for damages for the breach down the road. In great contrast, if a contractual term is construed by a court to be a condition, and the event on which one party's performance is conditioned does not occur, in most cases that party can walk away from the contract, in effect leaving the other party high and dry. Because the impact on the other party can be so significant if one party is allowed to walk away from a contract based on the non-occurrence of a condition, Restatement Section 227, Subpart 2, makes clear that if there is doubt as to whether a term in a contract is a promise or a condition, the preferred interpretation is that it be deemed a promise. As we have now learned, when the event on which a party's performance is conditioned does not come about, that party is discharged from its contractual obligations. Because this result can be quite harsh on the other party, on occasion the law excuses the non-occurrence of the condition. One circumstance that excuses a condition is impossibility. Assume an individual is injured in an accident, rendered unconscious, and remains in a coma for several weeks. If his insurance policy requires that he give notice within 10 days of the accident, that condition would be excused by a court based on impossibility. Another instance in which a condition is excused is when one party interferes with the occurrence of the condition. So imagine a situation somewhat like Pedersen v. Patberg in our casebook, where the party's closing of a deal is conditioned on, one, that the party's delivering a check to the receptionist in the other party's office by noon on Friday. When he arrives with this check, the other party has locked the front door of the office, making satisfaction of the occurrence of the condition impossible. In such cases where one party interferes with the occurrence of the condition, the courts will excuse that condition. Yet another instance where conditions get excused is that dealt with in the J&A Realty case, where requiring strict adherence to a condition would result in the other party suffering a disproportionate forfeiture or loss. As in that case, where a rental agreement conditions a lease renewal on the lessee's giving notice of renewal by a certain date, and the lessee negligently gives notice 1 day later, courts often excuse the condition and allow the lessee to renew the lease. A court is most likely to excuse the failure to give timely notice where the lessee stands to lose a significant investment if the lease is not renewed.